thank you very much for inviting the Fundamental Rights Agency here today. And I also would like to thank particularly Nuala, because she said two things that helped to kind of introduce what I was going to say. The first is the reference to good administration. And earlier this week, yes, it's still this week. Earlier this week, I was in the informal SCIFA meeting in Athens, and one of the main points that we tried to make there as Fundamental Rights Agency was that there are all these safeguards in EU law, these fundamental rights safeguards, but what we need to do is to operationalize them. And this is a point that, in a way, it's linked, in my view, to good administration, and it's also something where difficulties exist, and where I think it'd be interesting to reflect all together how that can be achieved. The second point, and here first I need to see whether I'm able to deal with the technology, as I'm not very good at it. Yes. The second point is that, in fact, I hope I will not deceive you if I'm not going to speak about the common European asylum system, but rather at something that comes before. Nuala ended her statement by the boats, the migrants on the boats crossing to Italy, to Malta, and the policies to address this situation where very different and divergent views exist out there to deal with this, with the plight of the thousands of persons that come. And that's what I would like to focus on. In fact, the common European asylum system, if you want to activate it, then you need to switch. I mean, if you want to actually switch it on, you need to reach first the house. I mean, the switch to have the common European asylum system starting is at the door of the European Union. You have to be at the EU borders or inside the country in order to be able to claim or to apply its rights and procedures and so on. And what I will focus on is elements of protection or risks that exist before. So I deviate a little bit from the overall theme, but I think that it's important to be aware that, on the one hand, there are very important fundamental rights issues that emerge before you reach Europe, and also that there are, under EU law, safeguards that are, in our view, not sufficiently operationalized, not sufficiently put in practice. I usually always explain what the FRA is about in 2 words, because afterwards, after presentations, I always get the answer, but what do you really do at FRA? So I think if you, the main part of the work we do is actually to take a picture on a particular fundamental rights issue and see and describe what happens on the ground. So how does EU law and the safeguards, the fundamental rights safeguards included in it, actually play out in real life out there? And one of these researches that we've done is this report here, which I saw that there are copies outside. I will not go through the findings of the report as such and to the recommendations by FRA, but I will touch upon 2 points or 3 points that we are trying to make in there that are linked in a way to the question of how can we operationalize safeguards that exist overall in the Schengen acquis or in the border surveillance legislation in the European Union. Maybe just at the beginning some figures, and I apologize for not being complete. Unfortunately, we don't have figures for 2013 yet from Greece and Spain. But just to have a kind of a sense about how many people we speak. Last year in Italy there were about 43,000 migrants and refugees who crossed, primarily leaving Libya to Italy, and about 2,000 to Malta. In Spain the numbers are likely to be the same as the previous year, and in Greece they will increase. As we speak, I mean, what is it now, 2 weeks and a half or so, or 3 weeks, in January, so far, over the last 3 weeks, in Italy there have already been 1,800 arrivals. So the figures are not huge if compared to the Syrian crisis and the neighboring countries around Syria, but it's if you think about the individual individual experiences and the situation of those crossing, they are not irrelevant. just very briefly, without going into details, where the roots are. I mean, this slide goes back to the situation in 2011. It's to a large extent still applicable today. One just should consider that arrivals from Tunisia have reduced substantially, and by contrast, arrivals by sea from Turkey to Greece have increased. Something that I also would like to mention here is although that's even further than the Schengen Borders Code, it's more part of the external action of the European Union, is that when we went out and interviewed migrants, particularly in Italy, but also very much so in Spain, what came to the surface, particularly when interviewing women, were the extreme degree of violence, very often sexual violence and abuse and exploitation that were experienced in the camps in northern Morocco. And now these days there's a lot of talk about the global approach to migration and mobility, so this new framework that the EU is putting in place to cooperate with third countries, particularly in the northern part of Africa, and Morocco is one example of this. And as part of this global approach to migration and mobility, one pillar of it is the construction or the promotion of an asylum space of protection in the third country, but it's usually intended as building an asylum system. And what we forget is that, in fact, what is necessary is also to make sure that the justice system in the country does not apply, in this case, only to Moroccan nationals, but also that the justice system that is in place also applies to migrants who found themselves there. And there I'm sure that a lot of the violations, a lot of the experiences that were reported to us are crimes also under Moroccan law. But let me come, in fact, to the 2 points that I wanted to how would I say, highlight here, where I think we need to reflect more on how fundamental rights safeguards can be operationalized. The first one that I want to, or the first point, looks at maritime surveillance, or surveillance, sea surveillance of the sea borders for immigration control purposes, so not for fishery or environmental pollution or others. And the second, which is even more problematic, and I think where all of us are called to think about how that can be, how the fundamental rights safeguards could be operationalized, is cooperation with third countries. In the report that I mentioned before, so in this report here, we illustrate a number of findings coming out from the research, ranging from refoulement instances that took place in the past or during the research. We did not, I mean, the report dates back to, I mean, the research itself dates back to mid-2012, so it was before the experiences in Greece, the increase of arrivals in Greece, arrivals by sea in Greece, and the related instances of refoulement and other violations that were reported subsequently last year by Amnesty, Human Rights Watch, and others. But in principle, instances of pushbacks have taken place throughout most of the how would I say, the Mediterranean or the southern sea borders, and this, in spite that there is a very clear provision in Article 3 of the Schengen Borders Code that refers to the need to respect or to apply the code in line with the principle of non-refoulement. A second issue which emerged that worried us quite a lot was a number of obstacles around making sure that the law of the sea system, the rescue system, is in place and is applied. Fishermen and private shipmasters, particularly in the central Mediterranean, so in ports like Porto Empedocle in Sicily or in Malta, told us, well, it is, of course, if we see, if we are out at sea all the time, rescuing people is indeed a humanitarian tradition to which we are very much attached to, and we will respect as much as we can. But there are obstacles. And not only financial obstacles or costs for fishermen, for example, or similar, but also legal obstacles and the risk that was perceived among many of the fishermen that they would be somehow either as a witness or even incriminated for facilitation of irregular entry. So that some of the rules set up to combat smuggling, smugglers or human smuggling would actually then target the work or target actions which were undertaken well, as part of a duty under international law of the sea, under national law in all countries, as well as as well as for humanitarian reasons, and this issue emerged again in the discussion after the tragedy in Lampedusa in October, where again the press reported the same thing, that fishermen risk this sort of reaction. I mean, we didn't find any case where a fisherman was any judgment convicting a fisherman of this, but what is important is the perception that exists among fishermen, or the awareness of the risk that they may face, and this, of course, has an impact on the way they act. And the third, and probably very complex issue, which I will just touch upon, is the fact that because there is no clear rules on where to bring migrants rescued at sea or intercepted and brought on a vessel, this controversies, particularly between Italy and Malta, about where should the migrants be brought, where should refugees or asylum seekers be brought, and the related delays with situations like last August, where for 3 days, I think, over half of a week, migrants, partly in very dire situation, were on board of a cargo ship 20 miles off Malta, because Italy and Malta didn't agree where they should be brought. Now, this happens in spite of the fact that there are a number of safeguards in EU law that maybe are formulated in general terms, maybe they are not sufficient tools on how to apply them in practice, but they are there. And I think the question for us at the Fundamental Rights Agency is what can be done to make sure that the non-refoulement provision that I mentioned before in Article 3 of the Schengen Borders Code, which has been further sophisticated in the revisions of the Schengen Borders Code last June, where it's not just a reference to non-refoulement, it's a reference to there is a reference now to the Geneva Convention, to the particular situation of persons in need of international protection. How do we get that operationalized? Or also Eurosur, the European Border Surveillance System, has at the very beginning, and even in its Article 1 that describes the purpose of it, the objective of saving lives of migrants or contributing to saving and protecting migrants at sea. What can we do to make sure that this is actually translated into practice? And here I think there are a number of ideas, some of them we've put in the report, but things like making sure that indeed information is passed on to rescue coordination centers, that if it's a rescue situation, that's not managed from an immigration control point of view, but it's really managed by those in charge of the rescue coordination system nationally and similar. One of the points we have, one of the problematic issues I think that exist in the current EU acquis regards an old directive from 2002 that's usually referred to as the Facilitation Directive, which basically implements, if we want to simplify it at the EU level, the Palermo Protocol on smuggling, which says that member states need to put in place criminal procedures or penalties, a set of penalties for persons who facilitate the entry or the stay of the irregular entry or stay of migrants. And there is, under EU law, no duty to exempt humanitarian acts from this setting up of penalties. And what we will soon publish will be an overview of how member states are dealing with this issue and to what extent, at the national level, these sort of safeguards for humanitarian acts have been introduced or not. So, for us, as regards maritime surveillance, we see that there is an increased attention, there's increased funds that are invested at EU at national level, at EU through Frontex in particular, into enhancing surveillance, but what sort of tools do we need that these provisions, these safeguards that are set out in the EU acquis are actually applied? And I think I'd be happy to have a discussion on this and get also your views on that. The second point is on cooperation with third countries. And here, if one looks at the work of the task force, the Mediterranean task force, and some of you may be familiar with the Commission communication that summarized the actions that the task force that the Commission has set up following the October tragedy of Lampedusa. If one looks at the 38 action points, the majority of those are somehow action points in relation that needs to be implemented in cooperation with third countries. I haven't counted them, but probably out of the 38, at least 25 or so for sure they are. And this shows, in a way, two things. First is that, in general, at the policy level, the solution is seen in much more cooperation with third countries, including countries where the situation is quite complicated, such as Libya, for example, and secondly, that the main focus is on preventing departure. But how do you achieve preventing departures? In many meetings where I'm in, the good example that is always reported to is the example by Spain and their cooperation with West African countries, particularly Mauritania and Senegal, where through bilateral cooperations, departure of migrant boats were basically reduced to zero, and therefore also situations of migrants drowning in the Atlantic between the Canary and West African coast was reduced to zero, to very little. But in that discussion, there is very rarely, or I would say almost never, a reference to fundamental rights. And what we saw is that in the discussion, in the cooperation with third countries, both operationally as well as when it comes to donation of equipment, donation of assets, or provision of training, fundamental rights is almost fully absent. If one looks at also the bilateral agreement that Frontex has with third countries, there is a very general phrase on fundamental rights, but it's very abstract, and it's difficult to see how that can be operationalized. Although there as well, EU law offers opportunities. Now, I'm not sure how familiar you are with Eurosur, for example. Eurosur is, for those who may not know about what it is, in fact, is a map of the European Union with a lot of dots or a lot of stars. I'm not sure what it is. And these dots are of three different kinds. One is a dot of all the incidents with all the arrivals, the irregular crossing of borders. The second is dots of where the fleets are, where the helicopters, the vessels are. And the third set of dots is information on what happens at the border, or rather at the other side of the border. And this is all information about situations, border management related situations in third countries. And there's very little in it that highlights the human rights situation in these third countries, which could inform those who operate the system that there are certain problems in Libya, that in spite of the changes in Libya, migrants are still held more or less in the same detention facilities under the same conditions that we had during the Gaddafi regime. So this sort of information is not in the system, but we need to find ways to get it into the system so that it's operationalized so that it's used by those who are in charge of that. And that's, in a way, the type of work also that FRA does in its cooperation with Frontex, which the consultative forum that advises Frontex hopefully can also support, etc. And finally here, I would just like to draw the attention on Article 20 of the Eurosur regulation, which I think is a very important article that regulates cooperation with third countries, where it clearly says that, first of all, personal data cannot be shared with third countries, but also that information that a third country can use to somehow treat the migrant in a way that would be contradictory to what is generally, well, Article 4 of the Charter, or Article 3 of the European Convention of Human Rights, or would subject a migrant or asylum seekers to other fundamental rights violation, cannot be handed over to third countries. But as you can see from this small map that I've put there, there are operational mechanisms to share quite a lot of information between countries. I mean, there are three regional surveillance cooperation on surveillance system in place. One in the eastern Atlantic with Portugal and Spain and a number of West African countries, one in the Baltic Sea and one in the Black Sea. And how does Eurosur and the information contained into it interact with this regional mechanism, and what is the risk that some of the information that is in Eurosur is passed on to countries part of these regional mechanisms? So these are some of the questions we are confronted with, together with finding ways to operationalize a lot of the provisions on fundamental rights that are in the revised Frontex regulations, for which contains quite a number of references to fundamental rights, ranging really from not only on training but also on how operations have to be set up, on the fundamental rights strategy, etc. I mean, how do we make sure that these are applied in practice? And I'd like to have, we really appreciative if you have ideas and suggestions also from your side. Just 2 points to end. First is that we will soon release a second and then a third report. The second report at External Borders will look at the 5 stars there. These are 5 large airports and what happens there. And the third report will look at what happens at land border crossing points. So not the green border, but land border crossing points. Both reports are expected in the next 6 to 8 months. And just to conclude, and maybe again to stress that there are fundamental rights safeguards in EU law which are often which are overlooked, or which are often which may get forgotten. I would just to remind again the handbook that the European Court of Human Rights, together with FRA, have published with the help of the IRIS Center and Nuala specifically, who is sitting here, where we try to summarize the main fundamental rights or the main human rights elements in EU law or in European law. So comparing European and the European Union and the Council of Europe system on each of the issues, which we have updated until the end of December this year, or last year, and which will then be available in 11 languages probably around April this year, and where I would be very happy to discuss with you how we could then promote this handbook at a national level in the various countries. I just want to remind that the languages will be Bulgarian, Romanian, Greek, Polish, Hungarian, Italian, German, French, and English, Croatian, and what did I miss? I missed one. Spanish. Thank you. And here, just to end, I'd just like to end here and thank again for the possibility to share a little bit the findings of the Fundamental Rights Agency on the issue that is a bit outside the European asylum system, but still, in my view, very much relevant and very much related to it. Thank you.